Good morning, Mr. Patterson. Can you see and hear me okay?
Yes, I can, Judge. Thank you.
Give a moment, let the prosecutor log back on. And I was going to tell you, I've got Dr. Mitchell Dunn. He's going to be calling in, but also in on this Zoom hearing. So we're going to go ahead and call this case first and get y'all out of the way if you are ready.
Yes, thank you.
You're very welcome. All right, this is cause number CR09-00382, State versus Jeremy Thomas Brown. At this time, the court is going to attempt to zoom in by telephone Dr. Mitchell Dunn, MD of the Forensic Unit of Terrell State Hospital. Dr. Dunn, are you there? Let me ask him to unmute. I'm going to prompt him to unmute. We'll see if he can hear us. Dr. Dunn, this is Judge Chris Martin in Van Zandt County. If you can hear me, I will need you to unmute your telephone device. I'm going to send you a prompt.
Yes.
Okay, Dr. Dunn, can you hear
Yes, sir.
me? Okay.
Yes, sir.
Okay, good. Thank you for joining us this morning. This is Judge Chris Martin. We are in the 294th District Court, and we are on the record, and the court has called cause number CR09-382, State versus Jeremy Thomas Brown. I appreciate you joining me today. Also involved in the hearing is Ms. Hillary Heisel, Assistant Criminal District Attorney for the state, and also Mr. Richard Patterson, attorney for Mr. Brown. I appreciate everyone joining me today. I understand that Mr. Brown has executed a waiver, I believe, and the court is reviewing the renewal order of civil commitment pursuant to 46-261. So I wanted to just have an update from the hospital, Dr. Dunn. So what I'm going to do at this time, Dr. Dunn, is I'm going to place you under oath. So if you'll just raise your hand where you're at. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, I don't know. My name is Marcus Gardner. I don't know.
Okay.
I'm supposed to be in court today. My lawyer is Justin Weiner, and I'm not.
Okay. All right, Mr. Gardner. There's a
Yes, sir.
mistaken identity here. All right. So
Yes, sir.
you're in the right place. I'm going to put you back in the waiting room. All right. Just stay where you're at. Okay. We'll call you back
Yes,
in
sir.
just a moment.
Okay. Yes, sir.
Glad he didn't serve as an expert.
Sir.
Glad he did not serve as our expert.
Me too. Me too. Glad he didn't go along. See, yeah, I was told that he was going to be phoning in, and that's the only phone I had. So let me try this one here. A Mitchell HD 7214. Let's try this one.
Dr. Dunn, here's Judge.
All right, Dr. Dunn. Well, we just had a very interesting thing happen in the case before you got on. It was my understanding that you're going to be appearing via phone today. And so then a phone number that I assumed was you. And we got halfway through just announcing the case, and the defendant in the other case told me, hey, I'm not Dr. Dunn. So, okay. All right.
I do want to let you know there is another Dr. Mitchell Dunn outside of Washington, D.C. in Rockville, Maryland. And every now and then I get lab results and test results from him. And I have to let those people know I'm not the person, but there must be some kind of national listing of doctors that people send out.
Well, at least he was a doctor.
Right.
That's-
Okay.
You've got that going for you. I didn't have that going for me. Okay. All right. We're going to reset a little bit. All right. So, Dr. Dunn, my name is Judge Chris Martin, and we are online in court, the 294th District Court. This is cause number CR 09382, State versus Jeremy Thomas Brown. As you can see, present in the Zoom hearing today, we have Mr. Richard Pattison, counsel for Mr. Brown, and Miss Hillary Heisel, Assistant Criminal District Attorney for the state. And the court has reviewed the order to renew the civil commitment of Mr. Brown. And I appreciate everyone appearing today. And I really just wanted to get an update on Mr. Brown. And that's why I asked for the appearance this morning. So Dr. Dunn, if you will, I'm going to place you under oath. Dr. Dunn, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right. Thank you. Ms. Heisel, do you have any questions of Dr. Dunn?
Judge, I'm sorry. Am I under? We do have a waiver on file. Is that correct?
We do. We do have a waiver on file. I didn't know if you had any questions of him. Otherwise, I can just proceed.
Yeah, Judge, I have no questions outside of what's contained in his report, which I believe the court also has a copy of.
All right. And I say that I have a waiver. I think what I'm looking at here is I got the physician's certificate of medical medical examination. I've got the renewal order. But I believe that the only waiver that I have, Mr. Pattison, correct me if I'm wrong. You know, I had the only waiver I have is not signed, but I have seen that in the past. But I don't.
What we did file a signed waiver with the court. That's dated the 23rd. That's notarized. Mr. Jeremy Brown's signature is notarized, and I've countersigned that, and we sent that to your coordinator, so I know that it's there.
Okay. All right. Well, Dr. Dunn, if you don't mind, will you just give me any kind of update that you can on Mr. Brown? I know that we can the court can authorize the recommitment of him based on this waiver and the renewal. However, I do like to have some information on kind of the status of how he's doing. And I've read the reports, and I think I saw that there's hope that if he can make some improvements in certain areas, that you believe that he could be outpatient soon. Is that correct?
That is correct, Your Honor. Although yesterday in meeting with Mr. Brown, he did indicate that he thought rather than the 2 to 3 month window that we were thinking about for him to show improved behavior, he might want to wait even longer. And I appreciate your interest in him because obviously he's been in the system for a very long time. I think I saw him the first time when he was probably 20 years old. He's been back and forth to a number of other hospitals and has now been back under my care for several months. And he suffers from a borderline personality disorder, which is essentially a longstanding situation in which he just doesn't tolerate frustration very easily. He's very fragile in terms of his capacity to tolerate stress. He also suffers from post-traumatic stress disorder from having had a history as a child of sexual and some physical abuse. And he has become or developed a kind of dependence on the institutional system. What he gets here, obviously, is care and concern from staff after he shows his frustration. And as you're probably aware, Your Honor, in the past, that's the degree of frustration that he's exhibited has led to self-abuse and suicidal thinking, including on 4 separate occasions, breaking glass and slashing his neck. On at least one occasion, required him to go to the hospital and be intubated. And he actually has had some swallowing difficulties for a while, which have improved fortunately over time with the help of speech pathologist and changing diet and those kinds of things. What I've seen from him over the past year or so is an improvement in terms of his capacity to tolerate frustration. He's learned how to go to staff rather than engaging in the self-abusive behaviors, at least more frequently. He's learned how to do that. He's also started writing poetry. He's become quite adept at drawing. So he has moved towards using those types of skills to try to tolerate frustration a little bit better. He's also started journaling, and he's more willing to come to the staff. At the same time, I think he's very frightened about the idea of getting out. He's spoken about this. He realizes that in the hospital setting, he can always go to a professional, but outside the hospital, he may not have that. And he's had a lot of situations from family in which he's felt let down. He spoke recently about his mother having bought him some type of electronic game that he might have been able to play as a handheld game. She bought that for him for Christmas, but she opened up and started playing it and enjoyed it so much that she decided to keep it. And, for normal adults, that would be no big deal. But for Mr. Brown, that was just one more piece of evidence of frustration about how his mother seems to put herself first. So just in this past week, he felt like he was being bullied by others. And instead of just simply going to staff and complaining about it, he began slamming his hand into the metal mirror that we have on the wall in the hallway. And he did that repeatedly despite the staff trying to intervene. And it was estimated between 25 and 40 times he kept slamming his hand into this mirror. He knows that that's the type of self-abusive behavior that we can't tolerate. In fact, that's been what we've seen most recently here, since he has not cut his neck in quite some time. And we were at a point where I'd asked him to show no self-abusive behavior for a period of 2 months, and then we could begin the process of trying to get him out of the hospital. So he was quite aware that when he did that, we would have to start over for a new 2 months. And he didn't seem disappointed by that at all. So I think he was really sending us a message saying, I'm not really ready. And then yesterday, verbally, he told me, I'm not really ready. I think I need to, look at more time in the hospital, perhaps 6 months. And I've been very cognizant of the fact that he could see any plans to get him out as being threatening. So I've let him know, you're driving the bus on this, Mr. Brown. We do not at any point want you to feel that we're pushing you out of the hospital. We know how that can feel for you. You need to let me know, but let's work together towards a plan. And previously, he endorsed the plan of 2 months without self-abusive behavior. In the beginning, a rather long process to try to get him out. When he told me yesterday, even 2 months starting from the time he hit his fist weren't going to be enough, he wanted more. I said, that's what we'll work towards then. And so that was an update from when I had filled out that form just a few days ago to let you know that now we're pushing things out probably even further, allowing him at least to feel that he's part of the team that decides when things are best for him. So overall, in comparison to the way he was a few years ago, much more capable of tolerating frustration, more capable of verbally describing his needs rather than acting out, but still obviously a very fragile individual and who still might engage in that self-abusive behavior.
Thank you, Dr. Dunn. Mr. Patterson, do you have any questions of Dr. Dunn, or do you want to add anything to the
I
conversation?
do have a few questions. I have concerns based on the length of time he's been there, that if he does transition out, of the appropriateness or not of his father trying to establish guardianship over him, and whether I might send you the proposed physician certificate form to be able to help analyze whether or not you thought at that point he might be appropriate for guardianship, or tell me that it's not necessary. I just don't want I don't want him released and nobody be prepared to step in and help as much as they can. That's my concern.
Yes, I would be happy to fill out the physician's medical certificate for guardianship once that becomes necessary, or at least to evaluate whether that's the most appropriate.
Yeah, wonderful, wonderful. How would I get that to you?
Do you have my email? Because it's probably best to just do that. And I have forms, because I do that as part of my private practice. So I'm familiar with the 4-page form. I don't know if your court uses that, Judge.
It would be very, I'm sure the same, very much the same.
Yeah, so
right.
I have the form. I have that. You would not need to send me the form. I could initiate that. And it would just depend on whether the court wanted to submit an order for me to do that type of evaluation, or what the process would be. But in terms of the form, you would not need to send me the form.
Do you mind sharing your email with me, or is that?
No, I don't mind at all. It's Mitchell which is my first name, mitchell.dunn@hhs.texas.gov.
Is Texas written out?
Texas is written out.
Texas.gov. Thank you very much.
You're welcome.
That's all I have, Judge.
Thank you, Mr. Patterson. Any questions, Ms. Heisel?
You're on mute.
Not at this time, Your Honor.
All right, thank you, Ms. Heisel. Okay, then based on the information and evidence presented to the court has taken judicial notice of the waiver of right to be present at hearing on renewal order of civil commitment. Court also takes judicial notice of the physician's certificate of medical examination for mental illness signed by Dr. Mitchell Dunn on February 18th, 2021. The court finds that at this time, Jeremy Thomas Brown remains mentally ill and continues to meet the criteria for court-ordered commitment to a mental health facility. As a result of that mental illness, court finds that because of that mental illness, Mr. Brown is likely to cause serious bodily injury to himself, to cause serious harm to others, and is suffering from severe and abnormal mental, emotional, or physical distress, experiencing substantial mental or physical deterioration of his ability to function independently, which is exhibited by the proposed patient's inability, except for reasons of indigence, to provide for the proposed patient's need, including the basic necessities, food, clothing, health. Therefore, based on these findings, the court is going to renew its order of civil commitment for Mr. Jeremy Thomas Brown. And that'll conclude our hearing today. And again, I'll sign this order and provide this to you, Mr. Patterson, and to the hospital, Dr. Dunn, and to the state. And if there's nothing further, then we'll be adjourned in this hearing. And I appreciate your presence here today.
Thank you, Your Honor.
Thank you.
Press the
All right. Good morning, council. Hope everyone's doing
morning, Judge.
okay. Let's see. I've got a few people in my waiting room, and the ones I call first. Let me see here. Mr. Weiner, you have Marcus Gardner.
Yes, sir.
Before I bring him in today, what's going to be the announcement on that?
Judge, I spoke with the state and I read their response brief. We're going to withdraw our motion to suppress. We are negotiating actively, and I guess setting it for a docket call would be appropriate. Whatever you'd like to set it for, we just need some more time to try and come to a resolution.
Okay. All right. I'll bring him in. I brought him in earlier. I thought he was my medical expert from the Terrell State Hospital. And we had a pretty good dialogue. And once I asked for his opinion, he gave it to me and then told me he wasn't who I thought he was.
That's funny. He'd probably rather be that expert right now.
Let me bring him in.
Thank you.
Mr. Gardner, are you there, sir?
Yes, sir.
All right, Mr. Gardner. This is Judge Chris Martin in the 294th District Court. Again, I apologize for the confusion earlier. I've called your case now. Your attorney, Mr. Weiner, is present along with the prosecutor for the state. This is cause 161 CR 2162, State versus Marcus Dwayne Gardner. We were set today on the defendant's motion to suppress, I believe. What's your announcement, Mr. Weiner?
Yes, Your Honor. At this time, we're going to withdraw our motion to suppress. We're actively working towards a resolution in this case. I spoke with the state. They're okay with us getting some time so that we can try and come to a resolution.
All right, are you available if I were to set this case on March 23rd for docket call?
Jesus fucking Christ.
Mr. Weiner?
I'm looking right now.
I know you are. I didn't want Mr. Gardner looking through his calendar.
Sure.
Yes, sir.
March,
I'm here.
sorry, the 23rd.
That's a Tuesday, yes. Either the 23rd or the 25th, if one of those is better than the other.
The 25th at 9 in the morning would be great, Judge.
Okay, Mr. Gardner, we're going to set you for
Yes, sir.
another hearing on March 25th at 9 a.m. And you're going to
Yes, sir.
appear via Zoom that day unless Mr. Weiner tells you otherwise. If y'all come to some kind of agreement, Mr. Weiner may have you paperwork or something of that nature. So you stay in contact with Mr. Weiner and he'll give you instructions on what
Yes.
to do next, okay?
Yes, sir.
All right,
Yes, sir.
Mr. Gardner, stay in contact with your bondsman also. You're free to go.
Okay, thank you, sir.
You're welcome.
Yes. Okay.
That's all I have, Judge. May I be excused?
Yes, thank you, Mr. Weiner. Appreciate you.
Appreciate you. I always love reverse alphabet days, Judge. Thank you.
Yeah, it doesn't happen very often, does it?
No, thanks.
Have a good one. All right, let's see who else I have. Do we have any counsel that have their clients present in their office? Okay, I know that I've got Mr. Gray. Let's bring him in, Mr. Parrish.
All right, Your Honor, I see Mr. Gray.
All right, Mr. Gray, I'm going to ask you to unmute your device. All right, can you hear and see me okay, Mr. Gray?
Yes, sir.
All right, and your attorney, you may not be able to see him. You may have to move left or right on your device, but Mr. Jason Parrish is present in our hearing today. Go ahead, Mr. Parrish. This is cause number 18312, State versus David Lee Gray. And I believe that we were set for a contested hearing today. I have a note that your client has accepted a plea offer. Is that correct?
That's correct, Your Honor. We do not need a contested, we do not need to have a contested hearing. We have reached an agreement with the state. The state has sent me some paperwork. We're going to make a couple of adjustments to that paperwork. I need to get my client in to go over that paperwork with him, and then we should be ready to have this thing finalized.
Okay. Do you know about how much time you may need?
If we could have, but we don't need any longer than 30 days, Your Honor.
And Judge, this is going to be a plea for time in the county jail under 1244A. So if we could reset it for a 1:30 jail docket, that would probably be most convenient for Mr. Gray.
Thank you, Ms. Heisel. Mr. Parrish, March 23rd, March 25th at 1:30. Which one do you like?
I'm a little concerned that I might have a jury trial up in Lamar County, March 23rd. I'm not sure though. So why don't we tentatively set it for March the 25th, Your Honor?
We can also go a little bit earlier. We'll have March 9th and March 11th.
Okay.
That week may be better.
I think March 11th would be fine. I don't have any trial conflicts on March the 11th.
Okay. All right. So, Mr. Gray, I'm going to order you to appear at the Van Zandt County Justice Center on March 11th at 1:30. That's a Thursday. And this will be the only that you get. Okay. Do you understand?
All right.
All right. March 11th, 1:30 at the Van Zandt County Justice Center here in Canton. With that, you're free to go.
All right. Thank you, Your Honor.
Thank you, Mr. Parrish. All right, and Ms. Morris will be our contested hearing today. Is that correct, Ms. Heisel with Mr. Murleader?
Yes, Your Honor.
Okay, I see her in the waiting room. I have a Chanel Tillman. Who has Chanel Tillman? Mr. Adams. Is Mr. Adams present with us? I do not see Mr. Adams. All right, and bailiff, do we have anyone present in the jail court?
Yes, Your Honor, we have all three of the 9 o'clocks. We have Mr. Ferguson, Mr. Atkins, and Mr. Leahy.
Okay, let's see here. All right, Mr. D'Angelo on, let's bring Mr. Ferguson up.
Mr. Ferguson, come on up, sir.
All right, are we conducting the plea today on Mr. Ferguson?
Judge, that is my understanding. There was a slight error on the judgment, so we were gonna correct that. But otherwise, I believe we're ready to proceed.
My air traffic controller has just entered the courtroom and she's told me to slow the runway down. Hang on just one moment. Okay, we'll recall Mr. Ferguson once we get the paperwork corrected. Mr. D'Angelo, if you've got another Zoom hearing, you can attend to that and we'll recall your case. All right, you also said, Deputy McLeish, that we had Mr. Atkins, and who was the other one?
Yes, sir.
Leha?
Yes, sir.
I do not see, is Mr. Stevens, Michael Stevens?
It's me, Judge, Mr. Rueda.
Mr. Rueda, okay, thank you. I was looking for Stevens. All right, if we can have Mr. Leha.
Judge, I think we had the same issue with Mr. Leha. We had the judgment that was, I don't know if it's already been corrected or not. But I signed the plea paperwork. I received it yesterday evening, but Mr. Leha has not yet. So I don't know if I need to be in a breakout room with Mr. Leha to go over the plea documents with him prior to the plea.
Okay. How were y'all anticipating him signing the plea paperwork? Were y'all wanting it sent out to the jail? And
well, that was the idea. I wasn't sure, to be honest with you, Judge. Like I said, I received the email yesterday evening, and one of my questions was, how do I get, if I needed to come up there this morning to have him, to be in person, that's fine. But I never really got a response as to how he was going to sign it. But I mean, if we need to have the paperwork sent, or if I need to come up to the jail to have him sign it, that's fine. I can head that way right now, and I can have him sign it, and then we can do it.
how far away are you?
About 45 minutes.
Let's do that. I hate to impose on you to do that.
It's not an imposition, Your Honor.
Okay, let's do that, and then you can just go out to the jail and you can sit with him and go over that, and because I'd be unable to put you into a breakout room right now because my other inmates are there, and so it would take up my ability to hear their cases.
That's fine, Judge. What time would we want to do this plea? I mean, I'd love to get it done today, so I have all day to get it done. I don't have a problem in doing whatever I need to do to get it done.
I believe that I'm anticipating one contested hearing and
Okay.
a couple of other announcements, so I would anticipate we would have this done before noon. So the sooner you get here and go over, we'll get it done this morning for sure.
Sounds good, Judge. I'll make sure and head that way.
Thank you, Mr.
Rueda,
Yes.
I'm sorry, gentlemen, to interrupt, but Mr. Rueda, when you get out here at the jail, if for some reason I'm not up here in this courtroom, please ask for me, Aaron McLeish,
McLeish.
and I'll do
Okay.
everything I can to facilitate this for you, okay?
Thank you, Deputy McLeish. I appreciate it.
Yes, sir.
Thank you, Aaron.
Maybe excuse, Judge.
Yes, thank you, Mr. Rueda.
Thank you.
Okay, Mr. Atkins. All right.
Your Honor, I don't
this-
know if you got the notice. I had filed a letter of representation actually about a week or so ago with the district attorney's office, and then I finally got the case number, and I filed it yesterday in the actual cause number.
Yeah, let me go ahead and call this real quick. This is
Okay.
for CR 20-237 State versus Chad Edward Atkins. And we are set for a motion to suppress today. Is that correct, Mr. Knoll?
Judge, I had filed that when I went and talked with the district attorney's office yesterday. They made what I thought was a very reasonable offer. In fact, I had plea papers prepared in hopes of disposing of it with a plea. I went over that with Mr. Atkins. Mr. Atkins then told me he'd hired Mr. Hunt. I don't know when that happened. Apparently maybe a week or so ago. The district attorney's office didn't know it. There was a letter of representation filed last night at 10:17 p.m. according to the notification of service. So if Mr. Hunt wants this case, he can have that in the other one that is coming down soon, I believe.
Right. And Mr. Hunt, did you file a motion to substitute or just a letter of representation?
Your Honor, I didn't even know he had a court-appointed attorney, to tell you the truth, and I didn't know any of his cases had been indicted. That's why I had sent a letter of representation directly to Ms. Curry, notifying her that I was representing him, and then I was informed that one of his cases was indicted, and so that's why I filed yesterday. I filed my letter of representation actually in the case. I will be representing him on this indicted case. Plus, I believe he has a couple more cases pending that have not been indicted. And I have not filed a motion to substitute because I didn't even know he had a court-appointed attorney until, I guess, yesterday. So I can do a motion to substitute if necessary.
Did he not tell you that he had a lawyer and has had a lawyer for quite some time?
No, well, no, I didn't know. I did not know he had an attorney. No.
All right, so he didn't tell you that.
I don't recall him telling me no.
And State, you're prepared to go forward today on the motion to suppress?
Yes, Your Honor. We have people here ready to go on that. So,
Mr. Knoll, are you prepared to go forward on the motion to suppress?
Judge, I could, but obviously if another lawyer has been retained, apparently for some period of time, I'm not sure how long, then I don't know that, to be honest with the court, that I should. If someone's being paid to do the job, it would be nice to have them do the job. I spent about 3 hours, part of that sitting in I-20 traffic that wasn't moving and meeting with the state and having a unfruitful conversation with Mr. Atkins, where he finally said he'd hired Mr. Hunt. Called Mr. Hunt's office, left a message, never got a call back. Again, got the 10:17 p.m. last night notice that a letter of representation. So I would quite honestly prefer not to proceed today since he has counsel. And I assume counsel doesn't have the video, which would be part of what this motion to suppress is about.
That's correct, Your Honor. I don't have any discovery yet.
Well, this is how I see it. We're set for motion to suppress today. It's been filed. The state's got their people ready. There's no motion to substitute counsel before the court. Mr. Knoll, you are counsel, you're court-appointed counsel on Mr. Atkins' request. Mr. Atkins, whether he's retained Mr. Hunt or not, he's got dual representation at this point. So the court's going to go forward on the motion to suppress today. State can put on their witnesses, and so we're going to move forward.
and Judge, real quick before I confirm that, let me confirm that, because I was under the impression as of this morning that we were not moving forward. So I released one of our officers. Let me go make sure he's still here. I believe he is. But as long as he's here, we're ready to proceed.
And what I'm willing to do is put all of you in a breakout room if y'all want to talk amongst yourselves about this. Otherwise, I mean, there's no motion to substitute counsel, and so I'm not going to discharge court-appointed counsel, and I'm not certainly going to allow Mr. Atkins, who doesn't tell Mr. Hunt that he has a court-appointed attorney, doesn't tell Mr. Hunt what Mr. Hunt needs to know to get properly before the court, to request a reset. And here in the 11th hour, we are. I'm not going to grant that. Mr. Atkins, should have told Mr. Hunt if he wanted Mr. Hunt to represent him what he needed to know. And I'm not trying to put anybody in a predicament or a sticky situation, but it is.
Judge,
Mr.
the only thing I'd say to that is Mr. Adkins' mother apparently has had substantial contact with Mr. Hunt, and it would have been the person that would have actually paid him. And I've had substantial contact with Mr. Adkins' mother. So I don't know why nobody knew that. The other thing that I would want to put on the record before we went and proceeded is the state had made yesterday an offer of 15 years on a case that is actually indicted 25 to life, as I recall. In exchange for a 15-year plea on a 25 to life, they would have proceeded on an enhanced state jail for 15. In exchange for that plea, they would have declined or 1245, I'm not sure which, I don't recall, don't have it in front of me, an assault family violence case, as well as not filing in, or again, 1245, another 25 to life case.
Go ahead, Ms. Heisel. Ms. Heisel, if you need to go check on your witness, go ahead. Go ahead, Mr. Knoll.
Which is the other unindicted case. So, but apparently,
and you've communicated those to Mr. Atkins, correct?
I did that yesterday, Judge, with plea papers in hand, and he said, basically the answer to that was I've hired a lawyer after I went over all that. And then I got Mr. Hunt's name. I contacted his mother, who said, to be honest, she said he had all that stuff and he'd filed all these motions and all this stuff had been done, but apparently that she was mistaken, obviously.
And I know, Mr. Hunt, you already said that you don't have discovery, so you're not in a position to counsel your client on those plea offers or the motion to suppress or anything else. So I understand the situation.
That's correct.
As well. I understand the situation both you gentlemen are in. Unfortunately for both of you, Mr. Atkins is the one who's put you here. So if there's going to be any frustration today, that needs to be at Mr. Atkins and not at the court. So I'm going to recall the case in just a moment. Mr. Atkins, you can have a seat, and whenever Ms. Heisel comes back, there she is.
Judge, our witness had not yet made it out of Canton. He's now headed back to the district attorney's office to proceed with this motion if the court wants that to go forward today.
Okay. So Mr. Hunt, Mr. Knoll, do you want me to put you in a breakout room with Mr. Atkins at all?
I think that would be a good idea, Judge.
Okay. All right. Give me just a moment to do that. And then state what I'm going to do next is that Mr. Adams has joined us. I'll call Mr. Adams and I've got a pro se, and then we'll recall Mr. Atkins. So give me just a second. Deputy McLeish, I'm going to invite Mr. Atkins to a breakout room. So when you get prompted, if you'll just accept that, and then just stay where you're at, and I'll bring you back into the hearing. Attorneys, you can return whenever you're done. Mr. Adams, are you ready, sir?
Good morning, Your Honor.
Good morning. How are you today?
So far, so good.
All right. I've got your client, Chanel Tillman, in the waiting room. So I'm going to go ahead and bring her in.
Good, Your Honor.
Hello?
Good morning, Ms. Tillman. Can you see and hear me okay?
Yes, sir.
All right. I want you to go ahead and put your phone down somewhere and just keep it real still, okay?
Okay.
Kind of get that situated for us, and then I'll call your case.
Okay.
Thank you, ma'am. Oh, all right. This is cause number CR 2350. and 316, State versus Chanel Monique Tillman. And Ms. Tillman, your attorney, Mr. Mitch Adams, is present in our hearing today. If you can't see him, you may have to swipe left or right if you want to see him. Mr. Adams, I show that we're set for pre-trial today. Is that your understanding as well?
Yes, Your Honor, that's right.
All right. Are there any contested pretrial motions on Ms. Tillman's case?
No, Your Honor, I haven't had a need to file it yet. I think this case was Mr. Cox's. I only point that out because we don't have a plea offer from the state yet. I just take this opportunity to let them know that if they're willing to make one, then we would be happy to look at that, and then Ms. Tillman and I can decide how to proceed with the case.
Okay. All right. Then what the court's going to do is set this case for a docket call. And are you available on either the 23rd or the 25th, Mr. Adams? I can't remember what I set you for on Tuesday, probably the 23rd.
It is the 23rd. And yes, I'm available.
All right. So Ms. Tillman, I'm going to order you to appear via Zoom again for a docket call on March 23rd at 9 a.m.
Okay.
And on that docket call, what I'm going to expect is, and Mr. Adams can advise you of all of the procedures that we're going to be going through. But what I anticipate is hearing from you and the state on whether or not you're going to reach a plea agreement to resolve the case by that date. And on that date, if there's no agreement between you and the state, then I'm going to expect you to tell me you want either a jury trial or a bench trial. And if we move past the 23rd and the case is not resolved by plea agreement and I set you for trial, the court's not going to entertain any plea bargaining after that. Okay. Do you understand?
Yes, sir.
All right. So you stay in contact with Mr. Adams, and if the state is so inclined to send an offer to Mr. Adams, then I would ask that be done well in advance of the 23rd so they could have time to really get a hold of that and discuss that between them so they can make an announcement to the court.
Could you have him to call me? Because I haven't heard from him.
I was just going to ask you, Ms. Tillman, is your telephone number
Hang
still?
on, and let's not say that over YouTube. So,
All
Miss Tillman or Mr. Adams, let me ask Miss Tillman, if I send you a chat, I want you to tell me if you can see this.
Okay. Yes, sir.
All right, can you reply with your phone number? And what I'll do is I'll send that to you, Mr. Adams.
Super, that'll work.
I'm trying to see how you go to the chat.
Well, let me do this then. How about this, Mr. Adams? If you'll send me your number that you want her to call. If you'll send that in a chat, I'll send that to her. Just go down to the bottom where it says chat.
Okay.
Okay, I got it.
Yeah, but both of you give me your numbers and I'll exchange them between you so you'll both have them. All right, Ms. Tillman, I'm going to send you Mr. Adams' number.
Okay.
And Mr. Adams, I'm going to send you Ms. Tillman's number. It's interesting, y'all both have the same.
Oh, I misunderstood you. Hang on a second. I'll send you
Oh,
mine.
Okay, no, okay, so you did have her number.
Yes. It looks like it.
Okay, yeah, send me your number, Mr. Adams, and let me send it to Ms. Tillman. All right, Ms. Tillman, did you get that number?
Yes, sir.
All right, write that number down before you log off so you don't lose it. And that's Mr. Adams' number. And he has your number as well.
Okay, I'm getting the pen now. I have it.
Okay, if you've got it written down, then we'll be adjourned in this hearing, and Ms. Tillman, stay in contact with your bondsman and your attorney, Mr. Adams, and y'all have those conversations before the 23rd if the state makes an offer.
Okay, thank you.
Thank
All
you.
right, you're free to go, Ms. Tillman. And that's, and let's see, Mr. Adams, you also have Tristan Kimmerling. So,
Yeah.
bring Mr. Kimmerling in this time. Give him a second to connect to audio. All right, Mr. Kimmerling, I asked that you unmute your device.
Yes, sir.
All right, can you see me?
Unmuted. Yes, sir.
All right, I'm going to ask you to keep your phone really still. Maybe if you can set it down on something and keep it stabilized, that will,
Yes, sir. Let me find something.
just put it down in one of those vehicles you're by there. That'd be fine.
All right. Oh, you can see me now?
Yes, thank you, Mr. Kimmerling. That I really do appreciate that. All right, this is cause number CR 2293, State versus Tristan Michael Kimmerling. And Mr. Kimmerling, Mr. Mitch Adams, your attorney, is present in the hearing. If you can't see him, you may have to move left or right on your screen. Mr. Adams, I show that we're set also for pretrial today. Any announcements?
Only that we don't have any contested pretrial this morning, Your Honor.
Okay, just want the court to set it for docket call.
That'd be fine, yes, sir.
And have you received an offer from the state on this one, Mr. Adams?
No, sir.
All right, court's going to set this for docket call on March 23rd at 9 a.m. Mr. Kimmerling, you'll appear via Zoom that day unless Mr. Adams directs you otherwise. And state if there's going to be an offer made in this case, I would ask that it be made well in advance of the 23rd so Mr. Adams can discuss it with his client.
Yes, sir.
Yes, sir.
So Mr. Kimmerling, you go ahead, sir. Did you have a question?
I don't have my attorney's number. Yes, sir.
Okay, well,
is there any way I can get my attorney's number?
Yes, I will send that to you in the chat right now, okay?
Yes, sir. Can I save it in the chat?
I'm not sure. You may have to write it down. So I'll send it to you and I'll give you time to write it down if that's the case, okay? And it should also, and it's also on the court order appointing him as your counsel. So if you have that, whenever you apply for court-appointed attorney, if you still have that document, it's down in the lower part of that document along with his address. That's the number right there. Did you receive it?
Okay, yes, I got it.
Maybe, I don't know if you can
I don't
screenshot
have
or
the
what.
paperwork. I'm gonna write it down. It's how to go to how to look at the chat.
Did it pop up on your screen when I sent it to you?
Yes, sir. I can't find it now.
Oh, Mr. Kimmerling, I have a telephone number for your grandmother. I'll call her. That's all.
The Teresa Kimmerling.
If that's your grandmother's name, then yes.
Yes, that's my mom.
That's your mother?
I will call.
Yes, sir.
I will call the number I have and see how far we can get with that.
Yes, sir. Thank you. She has my number.
All right, good.
All right, Mr. Kimmerling, then you'll be free to go. We'll see you back on March 23rd. Make sure you stay in contact with Mr. Pickens at your bail bond, okay?
Yes, sir.
All right, you're free to go.
Yes, sir. Thank you.
You're welcome. All right, just a second. Mr. Adams, is that all you have today?
For the morning, yes, sir, Your Honor. I think we have Ms. Ozuna this afternoon at 3 o'clock.
Okay.
I will see y'all then.
All right. Thank you, Mr. Adams. Appreciate it. All right, State, I'm trying to bring in Mr. Garcia. Mr. Garcia.
Yes, sir.
Okay, I'm going to prompt you. I'm going to send a prompt to your phone. I want you to click it. It's going to say start video.
Okay.
Did you see it?
Yes, sir. And I pressed it.
Yeah, it should turn your camera on.
Start my video.
Well, apparently it's not working for us this morning. Can you hear me okay?
It says start video. Let me see. It's got a line through it though.
Yeah,
Like
you need to push it though to take that line off. You need to press it.
Yeah, pressing it. It won't take the line off. It says share in green.
No,
Just more. Let me see. Chat meeting setting.
it's that camera with the red line through it. You'll need to press that button.
Yeah, that doesn't do anything.
All right, well let's go without video. I saw you pop on just for a moment. I saw you and then you went away, so I know it should work. You can see me though, can't you? You can see me, can't you?
Yes, sir.
Okay. All right. Well, let's do this, Mr. Garcia. This is cause number CR 20-79 State versus Daniel Ray Garcia. Now, I guess, was there some confusion on your part as to when your court date was? Because we called your case on Tuesday.
Yes, sir. I don't know how that happened. I wrote it down when we spoke over the Zoom. I wrote it down. It says Thursday. I mean, my wife even took the day off like two weeks ago. I mean, when she put in for her day off, I've been having that date in my head. It's on the 25th. From that day, I've been telling everybody that I know that that was concerned with this that it was sort of 25th. I would have, yeah. I don't know.
Well,
I don't know how that happened.
So what I'm going to do is, I had issued a warrant for you because you didn't show up on Tuesday. I'm going to withdraw that warrant at this time. Okay.
Okay. Thank you, sir.
So let's talk about this. Are you going to have an attorney to represent you on the charge of unlawful possession of firearm by felon? You told me before you were in custody in Galveston County that you had an attorney or were getting an attorney.
Yeah, I spoke to my attorney, and he said that he doesn't do any cases in Van Zandt. That was the attorney that I had, wanted to represent me on this case. I did have an attorney for today that your Patty had said that I needed an attorney to represent me for today. I had spoke to the attorney that represented me in Galveston, and he said he could do this on the Zoom for today. But he's in Galveston, so he's going to not be able to represent me up here. I'm still trying to find somebody to represent me on this case, up here that's in the area. Um, with the weather the way it was when I got out, I wasn't able to do anything as far as make any money or do anything. Go to work.
Let me ask you this, Mr. Garcia. If I were to reset your case and give you a couple of weeks, do you feel like you can have an attorney hired and an attorney from this area that will represent you in this county?
In 2 weeks, it's going to be tight. Hopefully, I was hoping for maybe a couple of months, if anything, something like that in the time frame with there. I could get a retainer, probably together money for a retainer. But
this is what we're going to do, Mr. Garcia. I'm going to reset your case to March 25th. That's going to give you 30 days.
Okay.
All right. That's Thursday, March 25th.
I'm writing that down.
And that's going to be at 9 a.m., March 25th. Today's February 25th, so that'll be easy to remember.
Yeah, easy to remember that one.
9 a.m. You go hire an attorney and have them contact the court, and they can appear Zoom. You can appear Zoom on that date. But I'm going to need you to have that lawyer on this third-degree felony charge. Now, you understand that this carries a range of punishment of 2 years to 10 years and a $10,000 fine, so it's pretty serious.
Yes, sir. What was I gonna say? Could it be my lawyer from Galveston, and that he can do it by Zoom? Everything by Zoom?
It can be any lawyer who's licensed in the state of Texas that's willing to take your case and appear here when your case is scheduled for hearings. And right now, yes, they can appear via Zoom, but there may come a time that they're going to have to appear in person. So I wouldn't go hire an attorney that's
far away. Yes, sir.
I wouldn't hire an attorney that doesn't know who the DA's office, prosecutors are, doesn't know how it works, doesn't know the court system here, is not familiar with the bondsman. I would recommend hiring an attorney in this area. But to answer your question, it could be any attorney in the state of Texas who's willing to take your case and make an appearance in this court.
Okay.
So now listen, if you go and hire someone from Galveston and they get on a Zoom hearing and tell me that, hey, they're not going to represent you, then that's not going to be good.
Yes, sir.
Okay. So I'm giving you 30 days to try to get some money together and get on the phone and figure out who you want to hire. There's plenty of attorneys in this area and surrounding counties that do practice here.
Okay.
Okay.
All right, Mr. Martin.
All right. So March 25th, 9 a.m. You're going to report back via Zoom with your attorney, and you can call Miss Patty and get the Zoom ID number. Okay.
Okay. Thank you, sir. Thank you, Judge Martin.
Is today the same Zoom ID number? No. All right. You're free to go.
Okay. Would I use the same Zoom number, or do we?
No, it'll be a different Zoom number. You can call Miss Abraham at the court.
Patty?
We'll give
Yes,
it to
ma'am.
you.
Yes,
That's correct.
Yes,
All
sir.
right. All right. You're free to go.
Have a good morning. Yes, sir. Thank you.
All right, Mr. Murleader, I know you're hiding in cyberspace. I'm going to be with you in just a moment. All right, we're going to take a short, maybe like 5-minute recess so I can tend to some administrative things, and then we'll get right back at it.
Okay, Judge.
All right.
Let me get the camera real quick, sir.
All right, still, you ready? All right, we're back on the record. Cause number, thank you, Mr. Atkins. CR 2237, State versus Chad Edward Atkins. Mr. Knoll, Mr. Hunt, have you had an opportunity to speak with your client?
Your Honor, we did discuss the issue, the client with each other. And at this time, I'm going to make an appeal to the court to get a reset on this. I just got access to discovery this morning. I certainly don't have access to the video that's in question. And so I am not prepared to argue this. I can kind of give the court a timeline of what happened. I was retained by Mr. Adkins' mother on his behalf on February 11th. I sent a letter that afternoon to Miss Curry informing her that I had been retained on these, at the time, I think there were 3 charges. None of them did I know had been indicted. And in fact, I said unindicted on all 3 of them. And I got an email back. Yes, it was, I don't remember if it was the 12th or when exactly it was, informing that, yes, the case had been indicted. Then, of course, last week was lost due to weather. On the 22nd, or no, sorry, the 24th, which was yesterday, is when I found out that Mr. Knoll had been appointed. I was actually in a meeting until about 9 o'clock last night on another case. And so as soon as I got back to a computer, well, actually yesterday afternoon, Hillary emailed me. I think her email was sometime around 2 o'clock. I didn't even see it until 5 o'clock, asking me if I'd been retained, if there was a hearing today. And I wrote back, I said, I'm not prepared for a motion to suppress. I don't even have discovery yet. At a little bit after 5 o'clock last night. That was while I was still in my meeting. And then as soon as I got back to a computer, I filed my letter of representation. I was planning on doing a motion to substitute today, to substitute for the court appointed counsel, but I haven't even had a chance to do that. In the meantime, I had been working with Stephanie Abney earlier this week on getting access to the discovery portal. I got my code or whatever it is that you have to put in to get access to the discovery, online discovery. I got that actually in the email this morning. So I have not seen any discovery. Mr. Knoll was kind enough to kind of give me an overview of what he knows, but I haven't seen the video. So I'm not prepared to proceed on this morning, and I'm respectfully asking that the court give me a reset, even if it's 2 weeks or whatever the court wishes to give as a reset, just to give me a chance to get a copy of the video and to review the documents and go over it and actually have a full understanding of the case, Your Honor.
Okay. And Mr. Knoll, I look back in the court's file. This is our second setting on this motion to suppress, is it not? You're on mute, Mr. Knoll.
Judge, it is, but the first one was the state filed a motion for continuance because one of our witnesses was unavailable.
That's correct, Judge. So this would actually only be the first request to continue it with apparently new counsel. So the other thing is there were issues, obviously, sometimes for whatever reason, after doing this, going on 37 years now, sometimes defendants don't believe what a court-appointed lawyer tells them. And one of the things was, because you were the DA, you shouldn't be sitting on the bench now. Well, in the conversation, obviously that's something that shouldn't be sitting as the judge on the case now. And routinely, a DA usually handles the high profile, no besmirchment of any DAs, but, the murder cases, the terrible shootings, robberies, all those kinds of things. So the idea that you would have been directly involved, which Mr. Adkins thinks is of great significance in any of his prior cases, is probably incredibly slim, which was confirmed by Mr. Hunt that a DA doesn't have the time because of the administrative type operation that a DA has to do in making sure everything does get done. So that was one issue, again, that I think to some degree was confirmed by Mr. Hunt. I would ask the court again to, since this is our first request, and since apparently my 36 plus years going on 37 of doing this doesn't impress Mr. Adkins, then would request that the court allow Mr. Hunt to come in on the case. I do realize it's kind of late since this case is over a year old. But I think once the video is in hand, it's pretty simple, the potential issues as far as on the video. And I've actually, well, I would ask the court to give us a continuance so Mr. Hunt could get up to speed. If necessary, I'll meet him halfway somewhere between Athens. I think his office is in Athens and Tyler, and give him the video. That's not, no reason for the court to be aware, but that's not something that's available on the portal. You actually have to pick that up in hand, and I have the copy, and it would certainly make it available. I'm in Zoom meetings from 1 o'clock till 5 o'clock today with defendants in Smith County, but if he has nothing better to do, I'll drive halfway and give him the video today.
Ms. Heisel, Mr. Atkins has had you jump through hoops and bring witnesses and prepare, and as he has Mr. Knoll. What's your position?
I mean, Judge, the state is ready to proceed. I do believe it's a pretty narrow issue. One of my officers is not even working in this county anymore. So it would be somewhat of an inconvenience to get him back. Also, the other officer has told me that he is going to be at training for the entire month of March, which I'm sorry, maybe he said April, an upcoming month, which may interfere with the next contested docket setting. So Judge, the state's ready to proceed, but at the same time, I want to be fair to Mr. Hunt if he's going to move forward on this. I don't know, given Mr. Hunt and Mr. Knoll's conversation, if we did move forward today, who would be moving forward. So I guess the state takes no position, honestly, at the end of the day.
Well, right now, Mr. Hunt is retained counsel, but he's not the counsel of record. So Mr. Knoll would be the one moving forward until there was a motion to substitute or motion to join as co-counsel. So right now, the court would expect Mr. Knoll to argue his motion to suppress, and Mr. Hunt could assist or not, or whatever. I want to be fair to the defendant at if the state requested a continuance before and the defendant acquiesced to that, I do want to be fair to that. However, I do have concerns that Mr. Atkins is sitting in jail, and it sounds like if there's a requested reset that the state's not going to be able to bring its witnesses and would ask for more than 30 days. And so that's going to create another 30 to 45 or 60 days. Actually, it would be, we wouldn't have another hearing until April 29th. That'd be 60 more days of sitting in jail pending potential issue on suppression that the court could rule on and potentially, free Mr. Atkins at the conclusion of the hearing. Mr. Knoll?
Yeah. Well, Judge, I guess maybe we ask Mr. Atkins if he understands that it may be 2 more months before this was even heard. Would he be willing to set for 2 more months? And again, that would be on this case. There is another case that he is obviously not out on bond on, the new case. So, Mr. Atkins, are you prepared to set 2 more months till there's a hearing on this case, let alone the other case?
Yes, I have to, yes.
What is the new case?
Judge, it's also possession 1 to 4. However, I will just clarify for the record, I spoke with my witness. He's out in March, not in April. So if we set it for the last week of March, he would be available.
And is the new case, is the new F3 1 to 4, is it indicted or not indicted?
Judge, it's not indicted. However, I do plan to present it at the next grand jury. I have given Mr. Knoll discovery access to the police report so that he and Mr. Atkins could consult about the very high probability that case will be indicted within the next couple of weeks.
And I informed Miss, and that's what Miss Heisel told me yesterday. In fact, it was actually just finding a space apparently to get a grand jury in because of COVID, that it would be indicted pretty quickly. So that would also probably help to resolve all cases, I would hope. But Mr. Adkins still has his right to a jury trial someday in the future, whenever that might be.
All right, the court will grant the request, Mr. Knoll and Mr. Hunt, for an additional setting on March 30th at 9 a.m. And Mr. Hunt, if when you get into the case and review discovery, if you decide that you do not want to move forward, if you don't want to adopt Mr. Knoll's motion to suppress, I would want you to contact the court and let the court know so we can move it off of that date onto a non-contested date. Otherwise, I will expect to hear the motion to suppress evidence on March 30th at 9 a.m. and we'll appear via Zoom again that day.
And Judge, and I don't have a problem giving Mr. Hunt my cell number over this meeting. He can call me if he actually has time to meet. I do have Zoom starting at 1 o'clock. He can call me. My cell number is 903.
Mr. Knoll,
Hold on.
I don't think you want to put that on YouTube.
Yeah, yeah.
This is what I would recommend. Just go down to the bottom and share it in a chat.
There you go.
Be able to chat directly to Mr. Hunt. I mean, this is worldwide.
Yeah.
I know. I've learned this lesson the hard way.
I'm trying to get, am I in a chat? I haven't any idea.
Just down at the bottom, if you move your mouse down to the bottom of the screen, a little menu
chat.
pops up and says chat. Yeah.
And then you'll
click
have
on
to
that.
select.
You can pick just to send just a message to just me.
Okay, can you hear me?
I can hear you. Yes.
Okay, my cell number is.
Everyone can.
No, Mr.
Hold on.
Mr. Knoll.
No.
Mr. Knoll.
You'll have to hold on. I'm gonna send you a message, and that way you'll see it.
Okay, that's good.
Just send him your number, Mr. Hunt. Yeah. So
Oh,
Mr.
that's a good idea.
So Mr.
Okay.
Knoll, yeah, the chat is just a text function. It's just a gotcha. Yeah.
Okie doke. Judge, then I would expect then a motion to substitute would be filed way before March 30th. I hope to see that order, and and anytime Mr. Hunt wants to try to meet, when we both have the time, I'll get the video to him. So
And
stay-
Mr. Knoll, I just sent you a chat. If you put your mouse at the bottom of the screen, you'll see the little chat thing, and it should have a little indication that you've got a message. And if you click on it, you should be able to see that message.
Okay, I've got it. I'll call you here in just a minute when we both get off.
Perfect.
All right, Mr. Knoll, go ahead and start preparing your bill so you can get that submitted so I can order Mr. Atkins and his family to have that paid quickly.
I'll just do, the court knows I'm not hungry for overbilling. I'll, $500, I'll send a bill. I'm happy with that, even though it's a higher level case than that. I'm fine.
Well, you'll need to, since there's not a disposition, you'll need to send me your time and then I'll.
Okay, then I'll certainly send the court time, although I wouldn't want more than that. 'Cause
Okay.
it's probably more than that. Thank you, Judge.
All right, you're welcome. Is that all you have today, Mr. Knoll?
I believe it is, Judge.
All right, thank you, Mr. Knoll. Thank you, Mr. Hunt. As soon as you get that motion to sub e-filed, I'll grant that and get that circulated back.
I'll get that in here as soon as I get off of this meeting, Your Honor.
All right, thank you, gentlemen.
I appreciate your understanding. Thank you, Judge. May I be excused?
You may. Thank you.
Thank you.
Thank you, Judge.
Go on, have a seat.
Judge, if I could just have a minute, I'm going to go excuse my officer on that case.
Yes, go ahead. Mr. Murleader, do you need to speak with Ms. Morris at all in a breakout room before we get started?
No, Your Honor. She's not testifying.
She's not? Okay. All right, I'm going to go ahead and check on Mr. D'Angelo's client before we go, and let me see where we are on that, and then we'll get started. I believe that you're the only one remaining for a hearing, other than Mr. Leha, who will be a plea. So give me just one moment, okay, Mr. Murleader?
Yes, Judge.
All right, Mr. Murray Leader, I'm gonna try to bring in Ms. Morris. And Ms. Heisel, I see a C Hughes. Is that Charlie Hughes by chance?
No, Judge, it's Candace Hughes.
Oh,
Our
okay.
officer is on her laptop.
Do you want her brought in?
Yes, please.
All right, Ms. Morris, I'm gonna ask that you get situated, get your phone still, and make sure I'm not looking into a light so I can see you. She can't hear me yet, so let's let her get connected.
Judge Martin. Yes, sir.
Yes, ma'am.
We do have Mr. Ferguson in the room now. If we need to coordinate a meeting, we are ready at this end.
Okay, so has he signed all of his paperwork?
No, sir.
Okay, I believe that Ms. Taberham was going to put you into a breakout room with Mr. D'Angelo.
Yes, sir.
All right, so let me try this again. Was there not an invitation on your screen to join Attorney Room 1?
I stepped out. Let me see. I do have another. No, that's not the one. No, sir, I do not have that invitation.
All right, let me try to move you to Attorney Room 2 and see. Did you get that one?
No, sir.
You're not getting.
Judge, I apologize. I have Mr. D'Angelo in number 1.
Yeah, I know you do. I'm trying to get the jail in with him, but Deputy McLeish is not seeing the invitations to the breakout rooms.
Wait, Judge, I see a separate window that just looks like a regular general Zoom. It says join meeting.
Yes,
That's
you need
going
to
to
do
be
that
it?
one. Yes.
Okay, thank you,
Do
sir.
that one and.
We're leaving now.
Okay.
Well, no, we're not. I'll mute this in and call one of the coordinators for assistance.
Ms. Morris, I need you to go ahead and unmute your device.
All right. Can you hear me now?
I can. So I'm going to ask you to do something for me. I'm going to ask you to make sure you put your phone down on something so it's not moving around. And I'm going to ask that you angle it to where I'm not looking into that light because I can't see your face at all.
Okay. Let me walk outside. Maybe that would be better. I don't know, because my lighting's not good in here. Hold on 1 second.
I understand. Just, find a place that's comfortable where you can sit down.
Okay, is this better?
Yes, ma'am. Thank you.
Okay.
You'll just find
I'm
a
gonna
place to sit.
I'm gonna sit that way. It'll be more comfortable.
And, in your vehicle, if you want to sit in your vehicle, sometimes that's a good place because it's quiet and you can set your phone down. All right, Mr. Are you ready to begin?
Yes, Your Honor.
All right, this is cause number CR 2220, State versus Tasha Jean Morris. And we are set today on the defendant's motion to suppress for lack of probable cause to search the defendant's purse. Is that correct, Mr. Murleader?
That's correct, Judge.
All right, do you intend to call any witnesses today or is this the state's burden? Was this a warrantless arrest?
It was.
Yes, it was a warrantless search, Judge. So it would be the state's burden, and we have no witnesses.
Okay. All right, are you ready?
Your Honor, if I could have just a brief moment to go make sure our technology is working, and if not, I'll just bring the officer in here with me and then we'll be ready to proceed.
Yes, ma'am.
Mr. Murray Leader, can you hear everything okay from us, from our end?
Yes, I can hear you.
Ms. Heisel, have the officer say something. He's quite a distance back. Let's make sure that that's going to pick him up.
Let me just do this, Mac. Let me, I was about to say, since it's only you.
Yes, are you able to hear me?
Yes, I can hear you.
And sir, how do you spell your first name? Is it Mackenzzie?
It's Mckenzie, sir.
Name is Hughes also, correct? Your last name is Hughes, correct?
Chandler.
Chandler, I'm sorry.
Yes, sir.
Judge, Miss Hughes is a ADA in our office
Yeah,
for laptop.
Ms. Heisel, are you ready to proceed?
Yes, Your Honor.
All right. Do you want any opening argument?
No, Your Honor.
All right. You want to go ahead and call any witnesses today or put on any evidence?
Yes, Your Honor. The state would call Mackenzie Chandler.
All right. Officer Chandler, if you'll raise your right hand, I'm going to place you under oath. It'll be better if you can see me, right? All right, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Put your hand down. Now, Mr. Officer Chandler, during your testimony today, make sure that you do not speak over the attorneys. Let them ask their questions, and then they're going to give you time to answer. Have a court reporter in my courtroom with me. Very difficult if we're talking over one another. If you hear an objection from one of the attorneys, just stop talking, and the attorney will make their objection. The court will rule on that, and then I'll direct you when to proceed, okay?
Yes, sir.
Go ahead, Ms. Heisel.
Thank you, Your Honor. Officer Chandler, how are you currently employed?
With the state of Texas through Wood County Sheriff's Office.
And when did you begin that position?
At Wood County Sheriff's Office, it was January 1st.
And prior to January 1st, were you with the Grand Saline Police Department?
Yes, ma'am.
And were you the K-9 handler of the Grand Saline Police Department?
Yes, ma'am.
How long did you hold that position?
It was since 2017, became a K-9 handler in 2018, May of 2018.
Okay. And I assume that that means that you're a certified peace officer in the state of Texas. Is that correct?
That's correct.
How long have you been a certified peace officer?
Since September of 2017.
Okay. And what kind of training and education do you have to undergo to become a certified peace officer?
You have to go through a police academy, you have to be sponsored, and you have to be accredited through an agency.
Okay. And then, so you go to police academy, and then after you graduate from police academy, is there additional special training that you undergo to become a K-9 handler?
Yes, ma'am.
What are the requirements for that?
Well, you have to attend class. State of Texas, you don't have to attend a K-9 handler's course, but it is best for case law and all that to go to a handler's course. I've been through two. And
can you give me the approximate dates of those two handlers courses you attended?
The first one's going to be with Harris County Sheriff's Office, May of 2018 through July 2018. And then I just completed another one at the new agency with Houston K-9 Academy. And I just got out February 5th. That was a 6-week course.
Okay. And do you go to that with your K-9 partner?
Yes, ma'am.
And then after that course, do you train on a routine basis with your K-9 partner?
Yes, ma'am. It's federally mandated.
Who is your K-9 partner in Grand Saline?
In Grand Saline, it was K-9 Vigo at this time of this case.
Okay. And with FIGO, what was y'all's normal training schedule?
It would be every Wednesday we trained with the Region 1 K9 team. If I couldn't make that, then we train in Grand Saline with our DEA certified dope.
And then, so you had special certification to be a K9 handler. Did Officer K9 FIGO also have special certifications?
Yes, ma'am, through NNDDA, which is National Narcotic Detector Dog Association.
And do you know how long do those certifications last before a K9 has to be recertified?
It's annually.
Okay. And do you know if K9 FIGO was currently certified on December 27th of 2019?
Yes, ma'am.
Okay. Do you happen to know what the date of his last certification was from that date?
No, ma'am. I believe it's going to be in July when he was last certified.
Okay. And so on December 27th, of 2019, were you on patrol as a Grand Saline police officer?
Yes, ma'am.
And did you have occasion to stop a black Chevrolet S10 on that date?
Yes, ma'am.
Do you remember who the driver of that black Chevrolet S10 was?
Yes, ma'am. It was Michael Smith.
And had you had previous contact with Mr. Smith?
Yes, ma'am.
Did you observe any traffic violations or equipment violations on Mr. Smith's vehicle?
At the time of the stop, yes, ma'am.
And what were those?
His license plate was covered in rhino liner. As guess he was changing the color of his pickup truck and got overspray on his license plate to where it was unreadable.
Okay. And when you executed the traffic stop on Mr. Smith, due to your previous experience with him, did you come to find out that he had an active warrant for his arrest?
Information was received that there was a local warrant for him. I did not know he was the driver at the time of the stop.
Okay. So it was just after the stop when you approached the window that you realized that it was Mr. Smith that you had pulled over?
Yes, ma'am.
And did Mr. Smith have a passenger in that vehicle?
Yes, ma'am.
And who was that?
It was Tasha Morris.
Okay, and I know it may be hard to see on here, but do you see Miss Morris here in the online courtroom with us today?
Yes, ma'am.
And is that the same Tasha Morris that was in the vehicle on that date?
Yes, ma'am.
Did you notice anything unusual about Miss Morris when you made the traffic stop or when you approached the window to speak to Mr. Smith?
She was real fidgety, messing with her purse, belongings in her purse, and failed to identify. She did not want to identify to law enforcement at that time.
Is that unusual to an officer?
Yes, ma'am.
Okay. And did you have concerns about her behavior at that point?
Yes, ma'am. It threw some indicators for me.
Okay. And then Mr. Smith was taken in on the warrant. Is that correct?
That's correct.
And did Mr. Smith provide consent to search the vehicle after you placed him under arrest?
Consent was granted. Yes, ma'am. I went ahead and ran the dog, the canine, just to be sure.
Okay. So Mr. Smith gave you consent. Then did you notify Miss Morris that you would be searching the vehicle?
Yes, she was particularly abrasive with her purse. And so that's when I went ahead and ran the canine, because if there was an alert on the vehicle, that would grant probable cause to search the vehicle.
Okay. And that would grant probable cause to search anything inside of the vehicle that might contain narcotics. Is that correct?
That's correct.
Your Honor, calls for a legal conclusion.
I'm going to overrule the objection.
Officer Chandler, what substances is K9 FIGO certified to detect in a sniff search?
Marijuana, cocaine, heroin, methamphetamine, and ecstasy, also known as MDMA.
And did you explain to Miss Morris before you deployed K9 FIGO how the process would work and what substances he would be searching for?
I believe I did, yes, ma'am.
And then when you deployed K9 FIGO, did he make a positive alert on that vehicle?
Yes, ma'am.
Okay. And at that point, had Miss Morris told you anything about the contents of the purse or the vehicle or anything like that? Had she admitted at that point to any illegal substances or contraband in the vehicle?
She did not openly admit to substances being in the vehicle, but she did make a statement that the driver, Mr. Smith, threw something in her purse.
Okay, and was this before or after the K-9 was deployed?
I believe it was before.
Okay. And so after there was probable cause, did you begin a search at that point of the vehicle?
Yes, ma'am. Once probable cause was established by the K-9.
Okay. And based on Ms. Morris's statement that Mr. Smith threw something in her purse, is that where you began your primary search?
I began in the vehicle and then went to the purse and located substances in the purse.
Okay. And can you kind of elaborate on what you found inside of Ms. Morris's purse?
There was, I believe there was multiple baggies of a crystal-like substance that was believed to be methamphetamine. There was also prescription naproxen in the purse as well.
Okay, and those substances, were those sent off to the lab for confirmation by Gransoline?
Yes, ma'am. The crystal-like substance that was methamphetamine did turn out positive with DPS.
Okay. And Officer Chandler, were you wearing state issued or Gransoline issued body cam at the time of all of this activity and search?
Yes, ma'am.
Did you provide a true and correct copy of that video to the state of Texas and through the district attorney's office?
Yes, ma'am.
And if we had a copy of that video, would that be an accurate representation of the events of that day?
Yes, ma'am.
Your Honor, at this time, I would offer states one, which is the video footage from Officer Chandler's body cam.
No objection, Judge.
All right, did you mark that as states 1?
Yes, Your Honor.
All right, states exhibit 1 is admitted for purposes of this.
And Judge, just as a matter of housekeeping, after this hearing is concluded, I can get you a disc with that on it properly marked for the court's file.
Thank you, Ms. Heisel.
Your Honor, may I have permission to publish Officer Chandler's video?
Mr. Murleader, do you have something to say?
Judge, I was just going to ask Ms. Heisel, are you going to also provide the dash cam? Is that going to be an exhibit from the state as well?
The state is not planning on introducing the dash cam at this time for purposes of this hearing.
Okay, I was going to ask for the dash cam to be included. Judge, I guess I can submit that to you myself, unless the state wants to. I can open up evidence when it's my turn and I can submit that as evidence.
Okay.
Judge, I have no objection to offering it at this time, Your Honor. I believe it's a different view of the same events. I don't believe there's anything additional on the dash cam as far as I'm aware. So I have no objection to making that state's exhibit 2 and just including it on that disc for the court.
All right, so the state's offering state's exhibit 2, the dash cam video. Any objection, Mr. Murleader?
No, Your Honor.
All right, state's exhibit 2 is also admitted into evidence, but the state's only asking for permission to publish state's exhibit 1, is correct?
That's correct, Your Honor.
All right, granted, go ahead.
Judge, if you could just confirm that that's a full screen view for everybody.
It is a full screen view for the court.
For me as well.
Hello, how's it going? Doing good. Hey, the reason for stop, okay? Your license plate, it's got paint on it. I can't read it, and you have expired registration, okay?
Yes, sir. I knew about the registration.
Okay, you got your license and insurance?
I don't know if it's, sorry about that.
I'll get it.
I don't know if it's up to date, but it's just, like, it's up to date. I just don't know if that's the right one.
Okay. Do you have some ID, ma'am?
No, I don't have my ID on me.
Okay, what's your name? What you reaching for, buddy? Okay, all right. What's your name? Ma'am? I have to give your name. All right. Give me just a second, okay?
How you doing?
Doing good. You doing all right?
Pretty good. You remember how you said I might have, or that thing was going to turn into a warrant?
Which one? The truck?
Yeah.
Yeah.
Yeah, I talked to her and she said that she was going to be dropping all that because she was trying to get a hold of Eric Sanchez. I was like, I don't even talk to Eric Sanchez. We have no dealings.
I haven't seen him in a minute.
Yeah, I was like, you should have came to me instead of trying to come through somebody else. Oh, okay, well, I mean, I'm sorry. I was like, I tried to get a hold of y'all. I tried Willie, tried. Willie didn't let her go.
Okay. So when I guess you rhino line the truck with paint and you got it on license plate?
I think so.
Yeah. Because I can't tell if that F is an E or an F or what. And the W, it's all covered up.
I'm sorry about that. Yeah, I'll get that fixed. I didn't think it really got it on license plate that bad.
Yeah.
I knew I did the
registration.
the license plate light. I knew I did a little bit.
Ma'am, you mind staying on the phone for me? I don't want you to. You're calling your who? Okay, I don't want you to call somebody, come up and shoot me while we're on traffic stop.
No. It's okay.
Yeah. Well, I don't know if they match.
What?
Yeah, 8609.
Remember they used to have last time that I asked about that. No, I don't know.
I don't know. I'm not seeing the date that it goes through. I see the date that you might have paid for it for a month, maybe.
It's good. I mean, I promise you that. I know.
And Judge, I'm going to pause this really quick. Mr. Woodwike let me know that on y'all's end, the video is incredibly choppy and hard to view. Is that true for everybody?
It's not that difficult for me.
Okay.
It's a little bit choppy, but I'm able to hear and see.
It may just be my internet. It was very difficult for me to understand. I was just wondering if it was the same for everyone.
I will resume video. Well, I say that. I've made it mad. Judge, I may have to restart this, but I will get us back where we were.
Okay, I'm not seeing the date that it goes through.
That's good right there.
For a month, maybe.
I mean, it's good. I mean, I promise you that. I know.
Excuse me. Oh, is this your truck?
Oh,
Oh,
I'm
okay.
running through my boss.
Oh, okay. So is she your boss? Oh, okay. All right, well, give me just a second, okay? Actually, hop out right here and I'll ask you a few questions. Hop back right there, okay? Ma'am, if you just sit tight for me. Okay, give me just a second. Who's your passenger, man? Why ain't she 199? She got some warrants?
No, that's her. She's, I think her ex-old man has a problem or something like that. She's never even been arrested.
Okay. Fine, I'm just
Yeah,
curious,
I
you
know.
know. Where you headed to? Obviously here, maybe?
Yes.
Okay. Where you coming from?
Alba? Alba? Actually, I went and stole some silver in Emory. That's where we're coming from. Okay.
But you don't know who she is? You know who she is? Who's she? You know, if it comes out and I find out who she is, we're harboring her. I'm gonna arrest you, okay? Just trying to be honest with you.
It's actually,
We're main. So let me ask you this, okay? I said vein pumping in your neck. Okay. You're sweating.
Yes, I'm I don't know if that really that turned
The
into
warrant? I'm sure. I'll be honest with you. I do not know.
Right.
We're gonna find out here in just a minute. Okay?
Like I said, she was supposed to go. Okay. People say a lot. Oh yeah, I'm gonna do this. But
Come up. You got stuff.
yes,
And I can't tell what that is.
yeah.
Yeah.
You see what I knew though. That right there.
Yeah. So I'm gonna ask you this. Is there anything you I need to be aware of? Marijuana, cocaine, heroin, any meth?
I am really nervous because I haven't been in trouble since 03 or 04.
I'm not saying you're gonna be in trouble otherwise.
Right.
I don't know.
Just worried about that part.
I just wind of it, and I was gonna ask you about it, try to help them.
I mean, that's the only thing that.
Would you want somebody to help you out?
Yes, sir. And it did because I was able to get in touch with Willie Adams.
Yeah, I know Willie Adams. How's he doing? Do you know?
I have no idea. I don't even talk to him, but it's his mama's truck.
So, what's her name? Tina?
No, Tina's the sister.
Oh.
Her name's Linda.
Maybe
I believe so.
You mind if I check your pockets and all that?
No, sir.
All right, come over here. You ain't got nothing supposed to take me for anything like that. Would you care if I take a look in the vehicle?
That's fine.
Whose vehicle is it? You said you were buying it.
Yes, sir, I am.
I can take a look in the vehicle? Okay. Hey, I appreciate that. Anytime you want me to stop, I'll stop, okay?
Ms. Heisel, if you can just pause it for just a moment.
Yes, Your Honor.
I'm not sure if it was clear on your end. I know there was an exchange between the officer and Mr. Smith there regarding the search, the request. I didn't really hear. Is it more clear on the video when it's not being streamed as to what his response is? I heard him say that he was buying the video, and the next thing that was audible to me was the officer saying, "Well, if you want me to stop the search, you can let me know," or something like that. Is it more clear on the video?
It is, Your Honor. It is very faint because Officer Chandler is conducting a pat down, so he's not speaking in the direction of the officer, but you can hear a positive comment on the video, very faint.
And so I'll just tell counsel right now that I will definitely review this video again on a hard copy. But go ahead, Ms. Heisel. Thank you.
Thank you, Your Honor.
Why I enjoy that for me. They'll say that it's real.
Oh, that website?
And apparently none of it's really been real.
Yeah, give me just a second. Or if I can, 27. Text DL 02461655, 02461655. You can't roll around with expired registration, man. That'll get you every time. You're almost a month out. And with your plate obscured like that.
And Your Honor, since the court is going to review this video independently, and we are here just for purposes of Ms. Morris, I'm going to fast forward till when the officers come back into contact with her.
Okay, and then let me know if there's going to be any provision of confidential information or identifying information. And if so, then the court would want to know that before we stream it.
Yes, Your Honor. I know at one point, Ms. Morris does share her birth date. So if the court would prefer to go ahead and end the streaming process for the remainder of the video, this may be a good time to do that.
Okay, all right. I'll go ahead and stop the stream at this time so that we do not inadvertently provide any